The first question: what is your true relationship with the government? Welcome. For many, the English Constitution feels like an impossibly complex knot of traditions, acts, and unwritten rules. But what if it's simpler and more powerful than we've been taught? This course is about finding the single thread that unties it all. We will rediscover the true source of law in England, understand the fundamental role of the people, and by doing so reclaim the solid foundations of our own constitution. One day, driven by an unshakable feeling, you decide to search. You climb the creaking stairs, the air thick with the scent of age. You move aside old furniture, cobweb-laden boxes, until you finally uncover a large, heavy wooden chest, hidden beneath layers of forgotten things. It's unmarked, weathered, almost part of the floorboards themselves. You try the lid, locked of course. For a moment you almost give up, thinking it's just another empty relic. But something compels you to keep trying. You find a hidden catch, a secret mechanism, and with a soft click, the chest springs open. Inside, it's not glittering jewels or gold. Instead, you find ancient scrolls, documents covered in beautiful, flowing script, seals of power, and faded maps. Each document is a receipt, a deed, a title proving your family's ancient rights and liberties. They are not grants from anyone, but acknowledgements of what was always yours. They are the constitution of your family, written in plain sight, just forgotten. This course is your journey into that attic. The prom and lost, inheritance is the true English constitution. The powerful forces are the misunderstandings and misrepresentations that have obscured it for too long. We will open that chest, dust off those ancient receipts, and discover that the fundamental laws and liberties of England are not granted by Parliament or monarch, but are inherent. They belong to you, the individual. This is not about new rights, but about rediscovering the foundations of freedom that have always been yours. Join me as we unlock the truth. Who really holds power in England? For centuries we've been led to believe it flows downwards, from the top. But what if that's wrong? What if the entire system is built on a secret that's been hidden in plain sight? In this first module, we uncover the foundational principle of the English Constitution, the simple, revolutionary idea that you, the individual, are the true source of all law. Let's begin. Welcome. For many, the English Constitution feels like an impossibly complex knot of traditions, acts, and unwritten rules. But what if it's simpler and more powerful than we've been taught? This course is about finding the single thread that unties it all. We will rediscover the true source of law in England, understand the fundamental role of the people, and by doing so reclaim the solid foundations of our own constitution. Our journey begins with one simple question: who holds the ultimate power in England? For decades, the common answer has been parliamentary sovereignty, the idea that Parliament can make or unmake any law it wishes. This course will challenge that idea. We will explore the evidence that ultimate authority doesn't come from government, but from another source entirely, a source that has been overlooked for too long: the people themselves. So where does the law in England truly come from? Imagine a pyramid. Most of us are taught that power sits at the very top, with a monarch or a government, and that its rules flow downwards to the people at the bottom. The first and most important principle of the English Constitution is that this pyramid is actually inverted. It is the people, every single individual, from which all authority flows. Government is a creation of the people, designed to serve the people. It is the servant, not the master. This isn't just a philosophical wish, it is the logical and historical foundation of English law. Grasping this single idea changes how you see everything else. And that is the foundational principle of the inverted pyramid. Before you move on to the next video, I have a question for you. I'd like you to think about a modern government department or policy. How does viewing it through the lens of the inverted pyramid change your perspective on its duties to you as an individual? Pause the video, head down to the comments section below, and share your thoughts. We are really interested in reading your perspective. What if the government isn't your ruler but your employee? What if it has a strict, legally binding duty to act only in your best interest, like a trustee managing your savings? There's a powerful legal concept called fiduciary duty that says exactly that. In this module, we explore this overlooked rule and what it truly means to have a government that serves, not rules. So where does this powerful idea of a fiduciary duty actually come from? It's not an abstract political idea, it's a hard legal principle born from something called equity. Historically, the law could sometimes be rigid, and clever people could follow the letter of the law to achieve an unfair result, to create mischief. Equity is the part of our legal system that evolved to stop this. Its purpose is to act as the conscience of the law, enforcing fairness and good faith. From this powerful principle of enforcing good conscience, the entire concept of trust law was born, which is the direct source of the strict fiduciary duties we are about to discuss. In our first module, we established that all power flows from the people. So what happens to that power? It is entrusted to the government. This creates a very specific and strict legal relationship. The government doesn't own that power. It holds it on trust for the benefit of the people. This module is all about that sacred relationship. We will explore the legal concept of a fiduciary, which is another word for a trustee, and understand the profound and non-negotiable duties the state owes to every individual it was created to serve. So, what exactly is a fiduciary? It's a legal term, but the idea behind it is very simple and very powerful. Imagine you are asked to be the trustee for a child's inheritance. From that moment on, you have a fiduciary duty. You cannot use that money for yourself. You cannot invest it based on your personal opinions or friendships. You have a strict legal obligation to act only in the child's best interest. It is the highest and strictest standard of care known in law. This is the exact relationship the English Constitution establishes between the state and the people. Government officials are fiduciaries. They are trustees of the power the people lend to them, and they are legally bound to act only in the people's best interest. To make the distinction crystal clear, let's compare the two models of government. The model many of us have been taught or have absorbed by default is that of a ruler. A ruler believes they hold power by their own right, that they hand the law down to the people, and that they are free to act in what they decide is the national interest. The English Constitution demands the opposite. It demands a fiduciary. A fiduciary holds power only temporarily, on trust. They serve a pre-existing law that comes from the people, and they are legally bound to act only in the people's best interest, setting their own aside. The difference is not small, it is everything. And that is the crucial distinction between a fiduciary and a ruler. Before our next module, I'd like you to consider this. Think of one area of public spending that you feel strongly about. How does viewing that spending through the lens of a fiduciary duty, where the government is a trustee of your money, change how you assess whether it is being spent correctly? Share your advice in the comments below. In 1610, a constitutional showdown between a powerful king who believed he was the law and a brilliant judge who knew otherwise set the course for English liberty. This wasn't just a single case. It was a defining moment that proved once and for all that no one, not the king and not even Parliament, is above the law. In this module, we unpack the explosive cases, like Dr. Bonham's case, that established the judiciary as the ultimate guardian of our freedom. So what does this duty mean in practice? It creates a set of very strict rules. Think back to the trustee of the child's inheritance. First, they must obey the instructions in the will, the trust deed, perfectly. For government, the trust deed is the established rule of law. They cannot simply invent new powers, as was established in the case of proclamations. Second, they must act in good faith, with an honest intention to benefit the people. This means they must avoid any conflict of interest and are strictly forbidden from profiting personally, either directly or indirectly, from their public role. This isn't a moral guideline. It's a hard legal boundary at the heart of the English Constitution. We have established that the people are the source of law and that government is their trustee. But what happens when that trustee tries to overstep their power? That very question was answered definitively in the year 1610. This module is about the pivotal showdown between King James I, who believed his power was absolute, and the Chief Justice, Sir Edward Coke, who defended the supremacy of the common law. The case of proclamations is not just a dusty piece of history, it is the legal cornerstone that proves the monarch, and by extension any judicial, legislative or executive powers, cannot simply invent new laws or offences by decree. It is the moment a law was formally declared to be the king's master. So what was the actual ruling? What did the judges, led by Sir Edward Coke, decide? They laid down the law with absolute clarity. First, it resolved that the law of England arises from three sources: customs, common law, and statute law. Second, it reaffirmed the right to govern, known as prerogative, derived its authority from the people's common law which predates Parliament. This reasoning resulted in the ruling that the king cannot create new law. His role is to uphold the law, not invent it. The king cannot create new crimes out of thin air. He cannot simply decide that something is now a crime if the established law does not already say it is. And the king has no power to change or ignore the existing law. It is the inheritance of the people, not the property of the king. It is crucial to understand that this ruling did not render the king powerless. It clarified the limits of his power to what the law of the land allows. He could no longer act as a lawmaker, but he still had vital legislative and executive roles. He could not invent new laws or crimes, but he could still issue proclamations as a powerful public warning system, urging people to obey the existing laws of the land. Think of it this way. The ruling took away his ability to be the author of the law, but it confirmed his role as the chief promoter and enforcer of it. His job was to serve the law, not to create it. The ruling against the king in 1610 wasn't just about the monarch. It revealed a fundamental truth about the nature of all power in England. It leads us to an inescapable, logical conclusion. Think of it this way. If the king himself is subject to the law, how can an assembly of individuals, which includes the king, the monarch in Parliament, suddenly possess an authority that is superior to the very law its own power comes from? It is a logical impossibility. You cannot be the creator of the rules you are subject to. This wasn't an oversight. The same brilliant judge, Sir Edward Coke, addressed this very point in the same year, moving immediately to apply this logic to Acts of Parliament themselves. In another landmark case, the judge, Sir Edward Coke, made a bold ruling. He said that if Parliament passed a law that was simply against common right and reason, if it was fundamentally unfair or absurd, then the courts, as the guardians of reason, could declare that law void. This was not revolutionary or just one man's opinion. It was a principle supported by the judiciary fulfilling its constitutional duty under the rule of law, as expressed in the Confirmation of the Charters 1297, which states, "And we will, that if any judgment be given from henceforth contrary to the points of the Charters aforesaid by the justices, or by any other our ministers that hold plea before them against the points of the Charters, it shall be undone and holden for naught." It reaffirmed, using different words, that Acts of Parliament were equally subject to the same ultimate legal review as the king's own proclamations. The judiciary was confirming its role as the final arbiter of lawfulness. Crucially, Sir Edward Coke was not inventing new law, he was confirming it. His judgment in Dr. Bonham's case was the most famous expression of a legal principle that was already well established and understood. The power of the courts to hold statutes void if they went against the law of the land had been affirmed as far back as 1368, and was even implied in the Confirmation of the Charters in 1297. Coke's genius was in marshalling these existing precedents to prove that this was not a radical new idea, but a foundational and settled principle of English law. The judiciary of the time operated on this clear understanding. Statutes were subject to judicial review against the fundamental principles of reason and natural justice. This wasn't a revolution, it was a reaffirmation. The consequences of this single ruling are impossible to overstate. This was the moment that the English Constitution was saved from taking a path towards the divine right of kings and absolute monarchy that was common in Europe at the time. First, it permanently placed the executive, the king and his government, under the law. They were administrators of the law, not its source. Second, it clarified the true role of Parliament. Parliament's job is not to be the source of sovereign power itself, nor is its purpose to grant that power to the executive. Its constitutional function is to advise and consent to statute law, which creates a second constraint on prerogative powers, in addition to the common law, which is expanded on later. This ruling affirmed that the law is a distinct entity, superior to both king and parliament, and that parliament's role is to serve as the people's voice in that legal process. This is the bedrock of the rule of law. And that is why the case of proclamations is a permanent line in the sand. For your discussion prompt, this case from 1610 established that the executive cannot create new offences by decree. Can you think of a modern rule or regulation that feels like it was created by the executive without the proper authority of law? Let's discuss your examples in the comments. You've heard the phrase, "An Englishman's home is his castle." But did you know it's a legal principle so powerful it directly challenges the modern myth of absolute parliamentary supremacy? In this module, we reveal how the judiciary brilliantly adapted the ancient common law to limit Parliament's power, and how a simple right to be secure in your own home is the ultimate proof that its power has always had limits. In our last module, we saw how the judiciary established its authority over the king, and even acts of Parliament. But after the Glorious Revolution of 1688, a new, powerful force began to rise, Parliament itself. This presented a new challenge to the rule of law. In this module, we will explore the brilliant legal mind of Lord Chief Justice John Holt, who adapted the ancient principles of justice to this new reality. We will see how he developed a sophisticated new strategy, not to destroy Parliament's power, but to guide it, ensuring that it too could never overstep its lawful boundaries. After the Glorious Revolution, directly declaring an act of Parliament void became politically difficult. This required a brilliant adaptation of the established legal doctrine, and the architect of this change was Lord Chief Justice John Holt. While unequivocally affirming the core principle from cases like Dr. Bonham's, Holt executed a masterful shift in strategy. Instead of the courts saying, "Parliament cannot do this," their legal position shifted to, "Parliament, being a reasonable and just body, could not possibly have intended to violate fundamental principles with this statute." This created a powerful, interpretive presumption, allowing the judiciary to read and apply statutes in a way that guarantees they comply with the ancient rights of the people. It preserved the spirit of judicial guardianship in a new political age. Lord Holt's sophisticated strategy was immediately put to the ultimate test. The House of Commons claimed that its own internal rules, its privilege, allowed it to deny an individual his fundamental right to vote without any legal consequence. In the landmark case of Ashby v. White, the courts, with Holt's reasoning ultimately upheld by the House of Lords Appeal 1704, delivered a definitive answer. They ruled that parliamentary privilege could not be used to extinguish the common law rights of the people. This was a monumental decision. It proved that Parliament could not be a judge in its own cause, and cemented the judiciary's role as the ultimate impartial arbiter of what is, and is not, lawful for all bodies, including Parliament itself. So how does this high-level legal doctrine, this judicial power to limit Parliament, show up in the real world? It appears in one of the most powerful and well-known principles of the common law. An individual's home is their castle. This is not just a saying, it is the practical application of everything we have just discussed. It means your home is a sanctuary, protected from state intrusion unless that intrusion is based on specific lawful authority. This right doesn't come from a single act of Parliament. It is a fundamental right that has been acknowledged by the courts for centuries. It is the perfect, real-world proof of a limit on state power. The legal bedrock for the castle doctrine was cemented in the landmark case of Entick v. Carrington in 1765. The court delivered a judgment that resonates to this day, ruling that state officials could not force their way into an individual's home and seize their papers without specific and explicit lawful authority. The judge's reasoning was a powerful defense of liberty, famously stating that if a supposed state power is not to be found in our books, it is not law. This created a powerful and permanent default position in the English Constitution. The individual's right to be secure in their property and privacy is the starting point. The state, not the individual, bears the full burden of proving its legal authority to intrude. So how does a centuries-old principle about your home connect to the power of Parliament today? It is the key to proving that Parliament is not, and has never been, absolutely supreme. Think about it. If a Parliament is truly supreme and can do anything, Could it pass a law tomorrow, allowing officials to enter any home for any reason, without a warrant? Our deepest instincts tell us no. That instinct is the common law at work. The castle doctrine is a form of fundamental law that has existed for so long, and is so central to the liberty of the individual, that it effectively binds future parliaments. If a parliament can be bound by a pre-existing principle that it did not create, it cannot, by definition, be absolutely supreme. Its power is limited by the ancient and established rights of the people. Let's break the logic down into its simplest steps. First, the right to be secure in your own home is a fundamental principle of the common law, as we've seen. Second, the logic, a truly supreme or sovereign power, can by definition create or destroy any law it chooses. There can be no limits. This leads to the unavoidable conclusion: if Parliament's power is bound and limited by a fundamental right it did not create, then that power is not, by definition, the supreme authority in the land. The claim of absolute parliamentary sovereignty is a logical impossibility. The law is supreme. So if the law and logic so clearly point to a limited parliament, where did the modern idea of absolute parliamentary sovereignty come from? It is a much more recent theory than the ancient principles we have been discussing. Its primary source is Sir William Blackstone, who, writing in the mid-1760s, promoted a new and powerful theory of Parliament's absolute authority. This idea was later cemented by academics who selectively misapplied the work of Dicey, creating the widespread but mistaken belief we have today. This modern theory stands in direct contradiction to the centuries of settled common law and precedent that we have just explored. And that is the unbreakable logic that proves Parliament is not supreme. Now for your prompt, the castle doctrine was born in a physical world, but we now live in a digital one. How do you believe this fundamental principle should apply to your personal data, your private emails, and your online life? What should the digital front door be? We would value your advice on this in the comments. What if we've been taught our own history backwards? We're told that Magna Carta and the Bill of Rights were gifts, granted to us by the state. That's wrong. They were receipts, proof of ownership for rights the people already possessed, forced from rulers who had tried to take them. In this final module, we reframe our history, decode these receipts, and reveal your true constitutional inheritance. Let's start with Magna Carta from 1215. The historical context here is everything. King John was a tyrant who acted as if he was above the law. The barons of England, representing the people, forced him to agree to the charter at Runnymede. This was not a gift, it was a list of demands. Look at its most famous clauses. Clause 39 states that no free man shall be imprisoned, except by the lawful judgment of his peers, or by the law of the land. Notice the wording. It doesn't say, "We hereby give you the right to a trial." It confirms that law of the land is the existing authority. It is a receipt, forced from the king, acknowledging that a fundamental law already exists and that he is subject to it. More than 400 years after Magna Carta, the people of England once again had to present a receipt to a monarch who had overstepped his authority. After the abuses of King James II, assisted by his evil councillors, judges and ministers, he was replaced by the Convention Parliament with William and Mary, who, in their first parliament, affirmed this constitutional breach by James II when passing the Bill of Rights in 1688. Once again, notice the language: it is not a grant of new rights, it is a declaration of the ancient rights and liberties of the people. It explicitly forbids the monarch from suspending laws, levying taxes without Parliament's consent, or maintaining a standing army in peacetime. Each clause is a direct response to a specific constitutional breach of law listed in the heads of declaration. It is a powerful and detailed receipt, reaffirming the core constitutional principle: the monarch is a fiduciary, bound by the law of the land. And so we arrive at today. This entire unbroken historical line, from Coke's assertion of judicial review, through Lord Holt's brilliant adaptation, to the modern policing of parliamentary privilege, is not just a history lesson. It is an accepted and operational feature of our legal system. The final, undeniable proof can be found in our own modern court rules, Civil Procedure Rule 54.1 explicitly states that a claim for judicial review can be brought to determine the lawfulness of an enactment. This single line is the modern procedural expression of the principle established in the Confirmation of the Charters in 1297, further detailed in the common law from the 1600s, and was still settled law by the mid-1700s. It is the final admission that the judiciary's role as the ultimate arbiter of the lawfulness of all state actions, including acts of Parliament themselves, is a settled operational fact. So let's bring our entire journey together. We have untied the knot. We've learned that the people are the ultimate source of law, and the judiciary is its ultimate guardian. We've seen that government is merely a fiduciary of the power we lend it, and that Parliament itself is limited by the ancient law of the land, the people's customs and common law. And finally, we've reframed the great charters not as gifts, but as receipts, proof of ownership of the rights that are your property. Understanding this is not just an academic exercise. It is the recovery of your own inheritance. The English Constitution is not a dusty document in a museum. It is the logical, operational, and legally proven foundation of your freedom, and it belongs to you. And that is the power of seeing the great charters as our receipts. For our final discussion prompt, if these rights were never gifts from the state, but were pre-existing rights that the people forced the state to acknowledge, what does that imply about our own responsibility, today, to be vigilant in protecting them? We look forward to reading your final thoughts in the comments. Thank you for completing this foundational journey with me. The knowledge you've gained is your inheritance, but this is just the beginning. To help you master these principles, we have prepared a free, downloadable evidence guide that contains all the core concepts, key case law, and historical proofs we've discussed today. It is your personal blueprint to the English Constitution. The link is right at the top of the video description below. This guide is your first step. For those ready to explore our library and delve even deeper into the legal and historical framework of our rights, we invite you to visit our website, peacekeepers.org.uk. The Constitution is not a relic to be admired, it is a shield to be held and a tool to be used. Take this knowledge, make it your own, and continue your journey of empowerment.